introduction, Professor Larry Kramer, President and Vice Chancellor, London School of Economics, and Mr. Harish Salve, Senior Advocate, Supreme Court of India, former Solicitor General of India, King's Counsel in England and Wales. Mr. Das, over to you.
Good afternoon. I think all of you are just recovering from an excellent lunch that you must have had. And it really feels good for me to be here, although in a different capacity. And I have been participating in this conclave over the last few years, almost without fail. And I thank the Indian Institute of Economic Growth, the organizers of this event, and particularly Shri N.K. Singh for giving me this opportunity to be here. Now, as you can see, and as has been already announced, we have two eminent panelists here, and I am looking forward to an excellent discussion as much as you are. The topic for this session is reforming the legal architecture. In the modern times, when economies are developing and facing new challenges and getting over issues that come up from time to time, it goes without saying that the legal architecture of any country, or for that matter, the international legal architecture or the jurisprudence, should also evolve in tune with the requirement of our times, whether it is for individual economies, whether it is India or any other country, and also for the economic system at an international level. As you know, India is fast changing, moving towards its objective of attaining the status of an advanced economy, what we call the Vikshit Bharat status, 2047, when we complete 100 years of our independence. And these are also times where the international environment, whether geopolitics or from the economic point of view or the trade point of view, the international environment is very volatile. In such situations, the interplay between the legal architecture of a country or the international legal architecture and the evolution of individual economies and the international trade scenario, they become much more intricately linked. So in this background, I think today's discussion will be very productive and thought-provoking. Time permitting, we will take a few questions at the end. And with these initial words, now may I invite first the President and Vice Chancellor, London School of Economics, Larry Kramer, to give his remarks. That will be followed by opening remarks from Shri Harish Salve. Larry.
Thank you. And thank you. It's a privilege to have another chance to address you, and this time on a topic that I've spent many years studying. So what I want to talk about is less the specifics of the Indian system than the general framework for what it would take to actually have a legal system that will best serve the country's needs. And then Harish will, I think, apply a lot of this and other things that we've talked about to the specific situation. And the opening point, I think, is one everybody understands, although it really cannot be overstated, which is a reliable, dependable, trustworthy legal system is essential for economic growth. It's essential because if investors do not have confidence that if and when they get into commercial disputes, as they will, as everybody knows will happen, that they will get a fair, speedy adjudication of their outcome, they will stay away. It raises the cost of capital at the very least, but often it discourages, and there is a huge body of evidence on the effects, comparing different legal systems based on the quality of their judicial systems and its effect on investment and on the cost of capital in the different countries. So it's an incredibly important feature, although one that tends often to get lost when we just think about the executive agencies involved. In order to have the kind of legal system that generates that kind of confidence, essentially, I will just point to six features. The first is access. Parties need to know that they will have access to courts, meaning that there are a sufficient number of judges that there's not incredibly long waiting times in order to get your dispute heard. And that goes to the number of judges and the size of the caseload that they will have. Second, the court needs to operate by fair procedures, which is to say procedures that are perceived as fair, whichever side of a dispute you may be on, and in a system that is effectively administered. Again, if you file a dispute and you're able to get one into the court system, but it takes 5, 6, 7 years to dispose through processes that are long and Byzantine, that creates a massive discouragement. So you need procedures that are perceived as fair and that are effectively administered. Third, the outcomes need to be reliable and consistent. So courts work by precedent in a common law system, but even in civil law systems, precedent plays an important role, and the decisions, the way a code is interpreted and the way it's applied, have to be seen as fair from case to case and not arbitrary or different for reasons that do not have to do with either the law or the facts of the case. Fourth, obvious is a reputation, a strong reputation for non-corruption. Nobody's going to come into a system if they don't know whether they'll be able to control the outcome because someone else is going to do a payoff or because they will have to do one, or many other possible ways in which courts may be corrupt. The fifth, which is related to the fourth but also independent, is the judges have to be respected, which is to say the quality of the judges has to be perceived as high to really attract people and to have them feel confident coming into a legal system. So that has very much to do with who is appointed, how they're appointed, what kind of background they bring to the bench, and so on. And then the sixth provision, which relates to the first one, I said the first one is access. You have to be able to get access to a court relatively quickly. The case has to be is speedy dispositions. Again, if you file a case and you're not going to get the outcome for 3, 4, 5 years, that's a massive discouragement to investing in the jurisdiction in the first place. So that cluster of qualities are essentially essential, and falling down very much on any one of them will create problems. Falling down on many creates a much larger problem. Second point I think that I would make is one way to deal with issues like this that is often adopted. If you have, as the United States has, for instance, almost only generalized courts, then you can often have problems in different classes of cases because the judges may not be deeply expert in all of the different classes. So you can create, and many countries do, even the United States does in certain instances, create specialized courts where judges are appointed for having a particular expertise that they then develop over time. And you can see how that strengthens almost all of the qualities that I mentioned. The judges can become respected, you have a greater likelihood of getting reliable, consistent results, et cetera, because you have a bench staffed by people who are not only well thought of, but are deep experts in the field in which they're adjudicating. A next quality or aspect that's often important, in addition to having these courts, is to have a well set up system of alternative dispute resolution attached to it. So that might be arbitration, it might be mediation, it can be both. But the opportunity for parties that have come into the system to agree upon an alternative procedure that is still within the system, that is even faster and less costly for them, but that is also reliable, is a very important aspect that can increase the quality of the adjudication and so the attractiveness of the courts. Typically, the judges who staff, typically you want to staff your alternative dispute resolution with judges, and ideally former judges. So well-respected judges who have retired from active service on the bench, but who serve as mediators or arbitrators is a hugely successful way to do this. Just two final points. One has to do with, again, something that follows. You need to attract the best people for the bench. If you want the bench to be respected, it needs to be staffed by high-quality people. You are in a market, so that means you do need to think about salaries, and you do need to pay judges, if not the same kind of salaries that they could make in practice, salaries that are high enough to make the job really worthwhile. And that needs to be accompanied with the kind of support that they have so that the job is comfortable and worth doing. And through those kinds of devices, you then build the prestige of the court, which itself becomes a quality that helps attract good judges. And again, we've seen the differences in systems that do that and systems that don't. In the United States, the federal bench is perceived as highly prestigious and highly attractive. The lower state courts are not, and there is a massive difference in the quality of the judges and the quality of the adjudications that you get. I hope nobody is here from any of the American states, but it is true. Just trust me on that. The last point I think I would touch on is you do need to worry both for the credibility of the court and for the reality of the way it works on some form of controlling the court, of managing the inevitable situations when there are questions or concerns about the reliability of a disposition, whether there is corruption, whether somebody has misbehaved. And of course, you would hope that that never happens, but you know it's going to. Now, one feature to remember in thinking about this, when you set up a bench like this, or any part of the government, you need to think about how you're going to balance the necessity of independence so that the actors can act consistent with whatever their mission is, and the need for a degree of accountability to the political system. If you look at any constitutional system, you'll see every branch of government has a balance between independence and accountability, and the balance can be different. Some branches you're going to lead more towards accountability, say in elected branches, elections that are more frequent, districts that are smaller, directions that are direct, and some you may want more forms of independence to balance that off, so you might make the election at a longer period, you might have a larger constituency, and so on. But even when it comes to courts, you have to think about balancing independence and accountability. You have to worry about a court that is too independent of the political system as much as you have to worry about a court that is too dependent on it. And again, this can be done in different ways. The most typical way is to try and make, globally this is to try and make the judges very independent in their decisions, but make the institution in which they sit one which can be controlled through the political system, typically in the form of appointments. So if you have staggered regular terms with some form of political appointment, but once on the bench, the judge is fully independent, that's just one mechanism that can be used for ensuring the independence of the judges in deciding cases, but making sure that the bench can't get completely out of sync with where the rest of the political system and the country are. There are various ways to do that, but you do need to think about it. When it comes to discipline, then, it's important not to have a disciplinary system that is either fully controlled by the political branches or fully controlled by the judiciary itself. So you need to find some way of mixing that control and keeping it both independent from each and accountable to both. A typical way to do that, for instance, is to have a disciplinary system that is independent, but whose members are appointed through some kind of consensus between the two branches, something like that. In any event, it is important to think about achieving that kind of mix of independence and accountability in terms of how you're going to control the bench once it's there, staying away from the notion of direct political control, but also away from the notion of complete judicial independence. And then lastly is on an ongoing basis, just putting into place systems for ongoing judicial training, both of the judges and of their administrators. So that, for me, would be the kind of package of things if you want the kind of court that will be very attractive. And as was mentioned in the opening statement, I think it's a point in time where the world could use something like this. A lot of the trusted international mediation organizations have lost a lot of credibility over the last couple of years. And if you want to do something to attract a lot of foreign investment into the country, you can hardly do better than to become one of the few four in the world where people want to bring their disputes if they're going to have a commercial disagreement. Thank you.
Thank you, Larry. May I now request Sri Harish Salve to give his opening remarks.
Good afternoon. It's always such an education sitting next to Larry and hearing what he has to say. Picking up on his last point first, an independent judiciary is not necessarily an unaccountable judiciary. And I don't mean accountability in its pejorative sense. The political system makes sure that Parliament and the political executive refreshes itself every 5 years. judges once appointed continue in office with security of tenure, and that security of tenure ensures judicial independence. So it is then the need in civil society once in a while to revisit how our judicial system is working and to discuss openly and candidly where the strengths lie and, more than that, where the failings have been, and try and address them. I'm not going to speak about the philosophical notions of the rule of law and the Constitution and the need to have a justice delivery system for every common man, etc. Let's focus on economic growth. We have now come to accept that the only way India can fulfill its dreams, the only way India can be true to the preamble to the Constitution, justice, social, economic, and political, to each Indian is through the vehicle of economic growth. If that's the vehicle by which we will reach the destination which our founding fathers laid for us, how do we get there? We have to get there by foreign investment. A dear friend who will be speaking to you later in the day, Mr. Rafael, we were driving here together and he gave me some figures. He's speaking on infrastructure finance. He says India needs roughly $3 trillion of infrastructure finance, of which a back-of-the-envelope calculation is $400 to $500 billion in the next few years of private equity. The problem in this is, will private equity come to a system where the legal system doesn't guarantee you either speed or certainty? Larry spoke of two things. It has to be within defined timelines which are relatively short. Any dispute resolution has to be quickly sorted, and more so in the infrastructure space, which is so highly regulated. And certainty. You cannot have cases decided in accordance with the personal ideas of a judge. One of the greatest things I have seen in the English courts is you can safely predict which way a case is going to go. A good lawyer can always tell you which way a case is going to go. I am afraid it's no longer so for India. So that's the important point. Today, I know if foreign investors look at a higher internal rate of return while making an investment in India, because your justice delivery system is slow, who's paying the price for that? Each one of us, each Indian consumer is paying the price for that. So improving the justice delivery system is not a question of spending $300 million or $500 million more on judges' salaries. It is reducing the risk of investment in India. And then we are talking of billions of dollars saved by a small investment in the justice delivery system. What are the things we need to look at? We need to look, and let's focus in the context of economic growth. We need to look, first of all, at a system in which a start to finish of a commercial dispute is a year or 18 months. If somebody looks at the cause list of the Bombay High Court, Bombay is India's biggest commercial center. If somebody looks at the cause list of the Bombay High Court, suits there have been lingering for decades. Now that's not promising at all. I'm not picking on the Bombay High Court. They have their problems. They have 4 judges hearing cases. And if you have only 4 judges hearing cases, work manufactures itself. They don't get time. They barely get to finish their ex parte ad interim applications. So we need a quantum increase in the number of judges. But if you need a quantum increase in the number of judges, it's not a numbers game. How do you attract legal talent? Which brings up the second issue which Larry mentioned. What about the salaries in judges? I think on last call, if I remember correctly, we aspired to have 50 judges per million of population, which is way below the average of 90 and 100 in the more developed countries. I believe the de facto rate is running somewhere between 12 and 15%. Why? If you go out of Delhi and Bombay, and if you go into the other big cities, and you go to the courts of first instance, your district judges, those courtrooms have empty chairs. Judges are not available. People, the legal talent is not willing to come and join. Now, as Larry rightly mentioned, nobody as a judge expects to make the same amount of money as a good commercial silk. But at the same time, there has to be a salary which attracts you to a job. And my own experience, I can share with you very quickly. When I was Solicitor General, there was a challenge brought to the Supreme Court saying a national, in the district commission, they were not finding members. The judge summoned me, our Solicitor General, and said, do something about it. When I looked at it, they have a power to impose a penalty of 2.5 million rupees. The salary, all found salary, given to a member at that time of the district forum was 10,000 rupees, slightly less than what I paid my chauffeur. And you expect this man to perform the duty where disputes up to 5 million are going to go to him because consumer disputes. So this kind of unrealistic judges' salaries have to go. We need a proper commission to investigate what would be the salaries which would attract suitable legal talent. And we have to fix those salaries. The third issue is about domain expertise. All courts in the world, all good commercial courts in the world have come to terms with domain expertise. I must say, much as we lawyers love to, this time I can't blame the government. The government has done all that they can do. They have given us a modern Commercial Courts Act, they've given us a modern Arbitration Act. Why is it not working? Because we people don't let it work. And I speak so as a member of the Indian Bar. So what's going wrong? Judges, what have we done? We have taken the same courts, the same judges, and changed the nameplate. The same judge, the same court is now a commercial court. That's not what it was meant for. It was meant to attract a different kind of talent. It wasn't done. The rules may have to be changed. We may have, our constitution envisages an all India judicial service. Maybe we should have an all India, time may be ripe to have an all India judicial service for the commercial court. And it can be done, the states can agree, I'm sure nobody will mind, and have a proper selection system. Who will select the commercial court judges? It has to be a panel of experts. It can't be the present system where judges appoint judges. So once we start focusing on these problems, how do we fix the justice delivery system? We need speed and we need certainty. And the second thing about certainty is continuing legal education. I'm afraid for a change, the government has shown its capacity to change much faster than the judicial system. As a senior member of the Supreme Court Bar, I must confess that our Supreme Court judges have been very slow in adapting to new commercial principles and new commercial courts. They have done a good job, but there is no continuing legal education in our system. And for some reason, we Indians seem to believe once you're there, you don't need any further education. That has to change. Our mindsets have to change. We have to realize as lawyers, we are students like a doctor. A lawyer is a student all his life. Our environment changes, ecosystems change, regulatory systems change. Judges have to keep abreast and have to, more than that, tune themselves to what is the philosophy which is driving the country. And that is not compromising independence. As Larry mentioned, you can't have too much independence. You can't say, I will work as a judge, disconnected from the ecosystem in which I'm working. There was one time where we had a socialist ecosystem. The judges adapted to that. Come out of it now. We have realized the follies of the past. We have moved ahead. The governments have moved ahead. Policies have moved ahead. You can't be stuck there. And finally, what is the biggest problem which we are facing? Why do we not have, in the short term, what can we do? In the short term, we have provisions available in the Constitution. You can have temporary judges. You can have retired judges coming back and sitting in a courtroom and deciding cases. We have to, as Indians, rise above our pecking order syndrome. Or if a retired judge comes, will he be senior to the existing? Will he be junior to the existing? Which courtroom will he sit in? We have to come to terms that our judicial system is facing a crisis of confidence when it comes to commercial dispute resolution. The government has given us a very modern arbitration law. Does it work in India? I don't think so. It's not really working the way it should. Arbitration is not meant to be the first step in a long journey of litigation. But that's what it has become in India, partly because, again, the judges have not adapted to how arbitration awards are to be treated. You're not a court of appeal from an arbitration award, but that, again, is a change of mindset. So unless we focus on all this, unless we look at the points which I must say Larry has, with his experience and wisdom, brought up, accountability, speed, certainty, and real independence of judiciary, internal and external, which mandates, and it's a conversation for another day, how do we change a system of appointment of judges which is more credible, which is more transparent. Thank you.
I think very interesting points have been made with regard to interpretation of laws, with regard to independence of the judiciary, and also having at the same time a mechanism or a system of accountability. The other important point which was made by both the panelists is with regard to the need for faster dispute resolution, especially with regard to commercial disputes, and the need for domain expertise among all stakeholders and all participants in a judicial system. Not only the judges in the commercial courts, but also the lawyers, the advocates who are appearing in the courts, and also the various agencies, including the government, to be in tune with the, changes in commercial law, not just within the country, but internationally. Now, having said that, let me pose three issues on which I would invite both the panelists to give their comments. One, naturally, we are discussing in India with regard to the Indian legal system and the economic changes which are happening in India. And so how do you see India's legal and regulatory architecture evolving, and what are your thoughts on the way forward? You would all be aware that in the recent years, the government has undertaken significant reforms. I would say landmark reforms in the economic laws of the country, whether it is the goods and services tax, or the insolvency and bankruptcy code, or for that matter, the inflation targeting framework, or for that matter, the FDI policy, and also the criminal law system in the country, which were amended, which were in existence since the late 19th century. So how do you see the the regulatory architecture as well as the legal architecture evolving, and what are your thoughts on the way forward? And here I would also like to suggest that Larry could comment on the British part and perhaps the European continent. Of course, Mr. Salve is also familiar with both of them have great amount of expertise in both these areas. The second area which I would suggest that we could, where I would suggest that the panelists could comment upon, is with regard to the context of, decline in, let us say, the international legal architecture around multilateralism. WTO has become non-functional. International financial institutions, international institutions related to the functioning of multiple economies have also become, fairly not so active, if I can put it that way. So how do you sort of see the international jurisprudence in the current context? And the third, somewhat unrelated to the first two, but very important in today's context, is the issue of data protection and data privacy, which is, I think, uppermost in the mind of every government and every judiciary in the country. So these are the three issues which I would like to pose, and then let's see how it evolves. So could I start with you, Larry?
Sure. Let me say a bit on the first two questions. On the third one, I don't know that I have anything that I could say with, I could say things, but they wouldn't be intelligent, just because it's so specific on an issue that in India, I don't quite know what it is. Just in terms of how to think about whether and what kind of further evolution is needed. As I say, from what I understand, it's really an opportunity moment for India, and the fact that you've had all these reforms is itself part of the opportunity. So what Harish and I were talking about is really getting an institutional framework in place that is very specifically designed for what is the government's top priority, which is generating the kind of growth that is sought to get India into a high-income country over the next couple of decades. That's an amazingly difficult challenge in and of its own. And so the idea that it makes sense to say, with all the reforms that have been made, let's make sure that we have adequate, strong expertise to take care of the legal part of this and make us a very attractive place for investment to come, both domestic and international. And all of the other reforms, as I say, create, to my mind, an opportunity to cap it off by creating a really highly thought through kind of state-of-the-art specialized court to deal with that issue. To some extent, the weakening of the role of the UK and the EU in playing that role is a part of the opportunity. Likewise, with the decline of multilateralism, I wish I believed that this was a temporary thing and we were going to come back to some sort of strong set of global multilateral institutions. I'm skeptical about that, and I'm certainly skeptical about it for a while, which means going back to, remember, we had a legal system before World War II and before the 20th century, in which there was a lot of international trade and there were commercial disputes. It was obviously on a much smaller scale than we have now, but things were worked out. And the way it worked largely was particular countries were able to develop within their judicial systems the kind of reputation globally that made parties elsewhere in the world want to or be comfortable bringing their litigation there. It attracted investment and dealings as well. So there's an opportunity, in effect, if you can develop the right kind of judicial system, to have the kind of reputation, particularly outside of the kind of Western domain, that people come to trust the Indian courts much as they did the courts of the United Kingdom, or the courts of New York State, actually, is what it was in the 19th century and early 20th century. So again, if you can build the right kind of infrastructure and reputation, it's more than worth the investment.
I would start by, as a lawyer who's been over 4 decades in the game, start by thanking the government for the new trend of replacing old legal fossils with live organisms. A lot of the laws, old archaic laws, some of them written by the British Parliament for colonial India, have now been revamped and brought up to date. But there is always a time lag between Parliament and the political executive, where it has will and direction to make changes, and for the judicial system to come to terms with those changes and change its mindset to align itself with the policy of the law. The reform in economic areas has now brought us to a point where talking of judicial reform is not discussing a luxury. It is a compelling necessity. If we don't do this, I don't see India being able to achieve its dream of Viksit Bharat, and this time it will not be the government to blame. So I think we, all of us who engage with the legal system, need to do something about this. The collapse of the multilateral system shines the beacon light on how do we deal with this in the short term. Once we have courts which have effective justice delivery systems with the two characteristics of certainty and speed, people will not look for bilateral investment treaties to make the investments. I don't think today if somebody is making an investment in the United Kingdom, he's worried about a justice delivery system. He'll just sign a contract governed by English law because he knows it's one of the best legal systems. I believe somebody had done the statistics. 5 out of 10 cases in an English commercial court are not English cases. There are cases between people who have signed up to be governed by English law. So if you have, once you achieve that kind of reputation of your justice delivery system, you will not have to worry. But in the short term, multilateralism having failed, we have to look at bilateral investment treaties to give the kind of assurance and security investors need. We have had some bad experience with dispute resolution and bilateral investment treaty. We need a conversation on that, and we need to fix that. But I think that's the only short-term solution which we can have if we need to bring in pace into foreign investment and provide the kind of certainty which investment of this magnitude needs. And the third, and I'm sorry I keep coming back to this, if we need to improve the quality of our judges, we have seen that the justice, the commercial dispute resolution in the high courts, original side, is far more effective in the sense of inspiring confidence. So we need to convert all our high courts to have an original side. Now, how do we do this? We need a very large number of judges for our high courts. How are we going to get that? And one of the impediments, and people who have written books on judicial independence have also said independence must not only be external but internal. I have known of so many people who have refused high court judgeship because they say, we don't want our future careers to be in the hands of Supreme Court judges. We want to proceed on our own merit, not by depending on whether you curry favor with somebody for an elevation to the Supreme Court. That's one of the things which we need to think about. And we need to strengthen our high courts, create more original side in the high courts, or create an all India cadre service which is equal to a high court for commercial dispute resolution. Otherwise, I don't see this catching up with the pace of investment that we need.
I think taking off from where both Larry and Harish Salveji left, one issue is with regard to capacity building and the quality of the judicial pronouncements. I think both of them have alluded to it. In this context, may I ask, particularly Larry, since you are now heading an eminent academic institution, with regard to legal education, in the context of India or internationally, with regard to legal education, what would be your recommendation, what will be your thoughts on sort of reforming the system of legal education to start capacity building right from the time that a person is in the college, goes on to become an advocate, a lawyer, and perhaps then goes on to become a judge? That is one aspect. The second aspect also, with regard to, again, capacity building and faster dispute resolution, is the issue of use of technology in judiciary. And I'm happy to note that I think in the Indian judiciary, many judges have started using technology, especially artificial intelligence, to sort of in their judicial work. I was having conversation with some senior lawyers and also a few members of various high courts and other superior courts. Many of them these days, I am told, they use AI to have the related cases if they want to see the previous case laws or the the related judgments or orders passed by various courts. Many of them use AI. But one danger, again, a senior lawyer pointed out to me is that the AI also sometimes hallucinates. And one senior judge, one senior advocate told me, a senior advocate in the Supreme Court told me that he saw a reference to a particular, a case law. And he was surprised because he said, in my 35 years of experience, I had not heard about this case. And he went and checked. He found that there was no such case. So obviously the AI had hallucinated. So that danger is there. So just to sum up, legal education, reforms in legal education to enhance capacity building in the entire system. And number two, use of technology in judiciary, especially artificial intelligence. So floor is open to both of you.
So, thank you. Okay, I could do a whole session on legal education, what I think ought to be done. But so let me just say a couple of things. Traditional legal education has been focused around what we always talked about as teaching someone to think like a lawyer. So it's basically focused around a primary set of skills in terms of how to analyze a case, critical thinking, problem solving, learning to learn, like that. And the way I always thought about it, that should be about the first year of law school. That's not preparing you to be a lawyer, that's preparing you to be a law student. And now we should begin to prepare you to be a lawyer, which begins to layer on exactly the kinds of things that you're talking about. And the devices for it exist. So legal clinics are pivotal while students are in school, where you can take cases, they can work on the cases directly, but not in order to learn the nuts and bolts, because you pick the cases so that they can be managed slowly under supervision and teach them how to reflect on taking what they're learning in their classes and how it applies in a real context. Then you're never going to have somebody come out of law school prepared to practice law fully. There's just not enough time for that. So, of course, the idea after school, much as in medicine, is there ought to be some requirement of some kind of apprenticeship. Ideally, a clerkship if you're thinking about a judicial path, or even if you're going to be a litigator to really work inside a court, but some kind of apprenticeship for a couple of years. With respect to judges in particular, I've always thought the Europeans have a really good system where it is actually a civil service career path. So it functions like any other civil service. It doesn't have the same kind of problems where the judges are too independent, because the civil service itself has a balance of independence and accountability. But one relatively early in a career chooses to take that career path and is really trained to be a judge all along, so that by the time you're appointed to a bench, you have deep expertise in what's needed. Something like that. So the idea is just to be thinking about preparation as a continuing education all along, where groundwork is laid in your time in school, but the education never ceases. The last thing I would just note on technology, obviously artificial intelligence can and will transform legal education and legal practice much as it is going to transform every other kind of education and every other kind of practice. And I think the threats for any knowledge industry like law are bigger than some other industries. The key, though, I wouldn't make too much of the problems that you mentioned today, the problems of making up cases and hallucinations, because that will not exist in 5 years or 10 years, the speed with which this technology is improving. So we really want to ask ourselves, how do we want to use this tool? And the challenge for law is this. The very best lawyers or judges are able to exercise a kind of judgment, that's why we call them judges, a kind of refined judgment that comes from years of experience. That's going to be really difficult to create in technology. The problem is going to be that they only get to that point by years of doing the work that doesn't require that kind of judgment as they acquire it. And that work will be all doable by technology and artificial intelligence. And since the AIs will be able to do that for virtually free or low marginal cost, we've got to figure out how we're going to preserve a system that needs the young lawyers so that we can sift out of every 100 the 1 or 2 who are going to become those really sophisticated lawyers. And that's a huge challenge for the profession going forward, I think. But the answer to it can't be to not use the artificial intelligence, but to really rethink the economics of practice. And as I say, that's a different topic altogether.
Picking up on Larry's last point, I can never forget when my first time when I had the honor and privilege of being led by Mr. Palkhiwala, who's been the greatest lawyer India has ever produced, one of the finest the world has ever produced, where the 42nd Constitution Amendment was under challenge. And at that time, he called me at 5:30 in the evening for a discussion saying, I want every American case on a particular point. So how did I get them? I took a flask of black coffee and I sat in the law library till 8:30 in the morning, going through every digest, every book, the amount of knowledge you pick up that way. So that's what Larry was talking about. If artificial intelligence allows me to give a search command and get everything in 3.5 minutes, some lawyer has lost a chance to do that research. Now we need to balance that. But one thing which I think cries out for repair within my profession in India is equal opportunity. Friends in India call me up and say, I have so-and-so, so-and-so's niece, so-and-so's nephew, so-and-so's son. He has just finished his legal education in London. Can you take him as a junior in Blackstone Chambers? I said, no. I said, no, but you can take him in your... I said, first of all, it's not my chamber. I'm part of a set of chambers. And secondly, to become a junior tenant in that chamber or even a pupil in that chamber, you have to sit in an exam because there is the equal opportunity rule. Every bright young lawyer must have the same chance of becoming a pupil in Blackstone Chambers. I can't say so, and this nepotism in legal profession doesn't work there. So that is something, that's a change we need to bring in India, where lawyers should be under some kind of regulation that bright youngsters get a chance to work with senior lawyers on an equal opportunity basis. Technology in courts is very, very important, and let me tell you 2 areas where it will transform hugely. I have seen, we've been struggling in the Indian system to get live transcription. It's been there in the international, in England, it's been there in the US all the time. If you ever go into an Indian trial court, criminal court especially, where the judge is receiving evidence, that judge, even now, what dictates what is called the summary of evidence. So the witness says something, and then the judge dictates what he thinks the witness has said, half the time ending up with a wrangle with one of the other lawyers saying, no, that's not what my witness said, or that's not what that witness said. And it's a huge waste of time. I have seen recently, with using artificial intelligence, instant transcripts being created of what is being said. And if that can be provided, believe me, you will cut down trial time by 70%. Because what the witness says goes straight on, it goes verbatim, there is no wrangling about what the witness said, and it's all there, and the transcripts are available. It's done all the time in other courts. We need to bring this in India. And the third huge technological advance which has happened, and I have seen this myself in COVID times, access to justice. In a country like India, if you can have, for the average case, for big cases, of course, in-person appearances are always helpful because you interact with judges. But in a large number of cases, the kind of system which we have created, the virtual court system, has created huge access to justice to an average Indian to get his case heard now in Supreme Court. He doesn't have to come to Delhi, find a local Delhi lawyer, or bring his lawyer from his hometown, pay his travel bills, pay his air bills, pay his hotel bills. His local lawyer, who knows his case from start to finish, logs on to the website and argues the case in Supreme Court. And also psychologically, the lawyers who are not part of the Supreme Court elite clique, they feel more comfortable and less intimidated on a TV screen than or on a computer screen than they do standing in person before the judge. So technology has a great role to play. The only thing I want to say, and again, this has to be done, technology in courts should not be an option. It should be a way of life. I've seen a lot of judges say, oh, we don't need all this nonsense of all this technology. Please, it has to become a way of life. Mindsets have to change. We have to make the best we can of the technology to make things faster, to make things easier, and to make things more cost efficient.
I think some very interesting points and takeaways for all of us. Before I open the floor for questions or comments from the audience, I have just one last point which I would like to make. and also would like to have the views of both the panelists. You know, in the recent years in India, we have, the government has launched on simplification of various laws, the various acts. For example, the criminal law amendments, the old CRPC, IPC have all been replaced by new laws, and the language is far simpler. Or very recently, the Income Tax Act, you know, which was about 60 years old, more than 60 years, that also has been, the size of that law has been reduced, the number of sections and provisos and other subsections have also been reduced, and the language is made far simpler with the objective of reducing the possible misinterpretation or the avoiding potential areas for conflicting interpretations. So essentially it boils down to make the language of various acts and rules as simple as possible, so that not only the judges and the lawyers, they understand it, but a common person or a company or anybody who's running a business who also needs to understand what the law of the land is, he also needs to understand. So on this, may I have your comments and observations?
We desperately need simplification of the Civil Procedure Code. The government has revised the Criminal Procedure Code. In England, we had what in English courts are called the Wolf reforms. Lord Harry Wolff rewrote the entire rules of Supreme Court. And the current civil procedure rules are very user-friendly. He started by kicking out all the Latin phrases in the rules. It's plain English. A lay person can read and understand what the rules are. They are effective. They've cut through a lot of the formal nonsense which used to be in the earlier system. They give a lot more latitude to a judge conducting a trial in running the trial efficiently. And for the big cases, there is never a problem. You will have sophisticated lawyers on both sides. For the small cases, user-friendliness is very important. A common man with reasonable intelligence should be able to understand what's going on in a court. That's the change we need in our system. We need to rewrite our Civil Procedure Code in the same way in which we have rewritten all the other codes.
So just, just a historical point. In the United States, this problem was recognized as a huge issue in the late 19th century, and an organization was created called the American Law Institute, still exists today, I've been a member for more than 30 years, that was charged specifically with fixing this problem. And it worked incredibly well. They did a series of either what were called restatements of the law or uniform codes, and when charged with doing this, the reason they worked was it was a non-political organization. It was put together by lawyers who nevertheless were members across the political spectrum, which was a way of actually ensuring that as they restated the law or made efforts to simplify or change the phrasing, sort of nobody was getting away with sliding in political agendas. When that has happened, they tend to get caught and surfaced as a result and so on. And so over about a 100-year period, it's been an incredibly successful way in which to do this on an ongoing basis. Because to me, that's the key. If you're doing it episodically and having to create new commissions and special commissions every time, it's harder to develop the kind of credibility that's necessary for all of them, and you're often creating bigger fights to get a particular one done. Whereas, as I say, this is an ongoing organization. It doesn't even wait to be asked. Just they'll do a second restatement or a third restatement every 20 or so years just to make sure that they're keeping up to speed with changes in the law.
Thank you very much for all the observations. We are left with exactly 8.5 minutes. So if there are any questions from the audience, most welcome. Yeah, there. Could somebody hand over a mic there? Yeah.
Oh, it's to somebody else at the back, right? You didn't recognize me, it was somebody else. Okay.
Please go ahead. Yeah.
Okay, thank you. So thank you very much. That was very illuminating on the courts and the legal architecture. But as economists, there are two types of laws that we've been talking about a lot in India in terms of legal reform. One is relating to labor and the other is to land. Now, in 2019-20, the Indian government took some 29 archaic labor laws and consolidated them into four codes, which were very good if you just look at the written point. But in terms of implementation, now it's 5 years, you find that very little has happened. So the same thing is true if you take land laws. So for instance, one of the big constraints on land is that you can't actually lease in and lease out land easily because of in the 9th schedule of the Indian Constitution, all the tenancy laws are placed. And unless you have constitutional reform, individual states can pass it. The government of India provided a sort of legal model code, but very few states have adopted it. So my question is to you that once you've passed a law, and it's not necessarily going to come up for litigation, don't you need a sort of bureaucratic architecture for actual implementation? And I'd really like to hear views on that, because a lot of laws that are passed are not going to come to either High Court or any kind of court.
Yeah, I think we'll take some about 2 or 3 questions at a time and then come back. Yeah, there.
Hi, thank you. Justice Salve makes a very persuasive case that an investment in the legal system would actually help the Indian economy by reducing the costs of risk and investment. We didn't really cover this, but I wonder whether you'd apply the same intellectual framework that you've applied about the value of a Western legal system to China, because China attracts billions in investment, or has for many, many years. It doesn't have an independent legal system. It's quite open about that. So is China the exception that proves the rule? Or is there, in fact, an alternative way to do things?
Yeah, I think
sir.
one more question, then,
sure, sir.
yeah.
Thank you, sir. So both speakers put a lot of emphasis on quantity and quality of human resources in the judicial system, especially judges. I'm wondering if we should simultaneously not look at something else. When we look at ease of doing business rankings, 2-3 factors holding us back are commercial contractual disputes, property-related disputes, and delays. Should we not be asking who brings largest number of contractual disputes to judiciary? Vis-a-vis property disputes, what is the entity, what are the branches of the state that can make largest difference to property disputes? These are not the courts who define, delimit property rights, earmark them, and protect them. And delays are an outcome. If there is no screening at lower courts level, we see very little screening of cases. If there is no screening of cases, are we not incentivizing strategic manipulative litigation? And what we perceive as something, a problem with the judiciary might be a problem somewhere else. Thank you.
Yeah.
I'll take a crack at 2 of the questions. As far as whether China is the exception to the rule is something which I don't think I have the expertise to answer. But what I can answer is our Constitution promises us a system based on rule of law. So we must find solutions consistent with the rule of law. We pride ourselves as the largest English-speaking democracy in the world. I think that's the label which we stand by, and consistent with that, we must develop our systems. As far as disputes are concerned, you're absolutely right. Contractual disputes, property disputes are the ones which hold back the system. But in one sense, in the commercial world, all disputes are contractual disputes. Screening of cases is something which will come about if the changes are made to the Code of Civil Procedure, like in England, where judges can throw out frivolous cases straight away.
With respect to the first question, I think the answer would be, I would just say yes. That is, say, in addition to a judicial process that has all of these qualities, a lot of the legal issues are run through an administrative process, which is different, and you need to have the same kind of reliability and quality and so on. So it's not to say reform of this piece solves all of your problems. There may be other issues as well. It is to say, though, particularly in the international context, the dispute resolution, the judicial piece, is hugely important, and it's in the front of people's minds and an obvious thing. So it nevertheless, I think deserves special attention. With respect to the question about China, it's always a risk-return calculation. I mean, even lots of countries that don't have independent or reliable judiciary still get investment. If the potential financial return is large enough, you'll take more risk. China has been seen for a long time to offer incredible opportunities for returns, sufficient to persuade a lot of people to take the chance. What I would say is, if they fixed their judiciary and made it independent, they'd do even better. So the question is not, how do they do relative to, say, India? The question is, would any country do much better with a more reliable judicial system that could deliver the kinds of dispositions that we're talking about? And the answer, I think, is unquestionably yes. And as I say, there are a fair number of controlled studies that make a lot of these comparisons that would support that would include taking into account differences in the economic opportunity side as well. And then, just in terms of other cases, I don't know, I think again, my answer would be similar to the first one. What we were thinking about here is, to the extent that there's a focus on trying to achieve the, 8.7% growth, is that 8.7? Over a long period of time, what are the classes of cases where you'd be most concerned with ensuring the kind of adjudicatory processes that will make that not an obstacle, and in fact make that an attraction? So if it needed to be somewhat, how you define commercial disputes for that purpose would be something that you'd go into in deciding what the jurisdiction of the specialized court ought to be.
We have just one more minute. I see my old colleague, former colleague, raising his hand there. Please go ahead.
Thank you, sir. It's been a wonderful session and very analytical. On the issue of bilateral investment treatment, the BIT of India was allowed to lapse with many countries for two reasons. There was a tail risk that the Indian government perceived at that point of time, that they could land up with very high rates of judgments in terms of the monetary amounts. And B, I think there was a little bit also of this dissonance about the fact that the arbitrators in some of these independent arbitration councils had a kind of a revolving door relationship with firms of whom they were adjudicating. They could also become clients or on their boards, etc. later. The point that I'm trying to make is that the BIT for the Indian government was consciously allowed to lapse because of this distrust with this kind of arbitration mechanism. But it doesn't solve the problem, because on the other side, the private investor does not trust our legal system for the various reasons enumerated of speed, access, predictability, etc. So the point that I'm making for the panel and the response I'm seeking is that in this kind of impasse that operates, is it possible for the Indian government to think of a mechanism by which it allows the BIT to now come up that takes care of the fact that there's a threshold, and up to that threshold, go in for international arbitration if required. Beyond that, say if it is an award which will be, say, more than just as the figure, $1 billion or $10 billion, then it will be subject to the same legal jurisprudence of the domestic laws. Is it possible to have such a hybrid model, is my question, where we take care of almost about, say, 95% of disputes by allowing it to go, because we know that the tail risk is something which can be managed in this mechanism?
Yeah, I think, Mr. Salve, you would like to take it?
I can, India has had some bad experience with bilateral investment treaty awards. I don't want to comment on them because I know what went wrong, which can be very easily fixed. But you have a very valid point, and one of the easy solutions to that point, I think, is just make sure when you sign a BIT, you can agree to an international arbitration, make sure you say the venue will be United Kingdom. And the reason I say this is, the most effective control on runaway awards is by the English legal system. The English Arbitration Act gives more powers to judges than any other arbitration act. They have not followed the UNCITRAL model, but the judges know exactly which awards need to be upheld, which awards need to be thrown out. If you want an example of that, there is a case where there was a huge fat award against Pakistan, which was set aside by the English courts. That could be one solution in the short term.
Thank you. With that, we come to the close of this session. I would like to thank Larry Kramer and Harish Salve for being so responsive to the questions and the comments. So thank you.
Thank you very much. We will now begin